Hello everyone. So in the background of the judgment which Supreme Court passed in the month of April 2025, where Supreme Court curbed the pocket veto power of governor, meaning if a bill is passed by state assembly and then reaches to the governor has to act on that particular bill within a specified time. Here Supreme Court had said 3 months, and that too if governor reserves the bill for the consideration of President of India, then President also has to act within 3 months, because such timeline were prescribed by Supreme Court on governor as well as President of India. Now what President has done is, President using her power under Article 143 of Indian Constitution has posed or asked 14 very serious constitutional questions to Supreme Court. So in this particular video, we will be seeing what are those 14 questions, then in what background those 14 questions have been asked. So first, to understand, because President has used Article 143 to ask these questions to Supreme Court, let's try to understand what is Article 143. So Article 143 says, if at any time it appears to President that a question of law or fact has arisen, or it is likely to arise, which is of such a nature and of such public importance that it is expedient to obtain the opinion of Supreme Court upon it, he may refer the question to court for consideration, right. So if President feels that a topic or an issue which has already arisen or it might arise in future, a question of law, right, then President can refer such a question of law to Supreme Court. But please remember, here Supreme Court is not bound to give opinion, right. It is discretionary on Supreme Court either to give opinion to President or not to give opinion. Secondly, because it is an advisory jurisdiction of Supreme Court, meaning the advice given by Supreme Court are also not binding on President. So two things: firstly, it is not mandatory for Supreme Court to give advice. Secondly, even if Supreme Court chooses to give advice, it is not binding on President. Now let's see the background of the issue, why President has asked these 14 questions. So as you all might be remembering, that in the state of Tamil Nadu, what happened was that the Assembly of Tamil Nadu, State Legislative Assembly of Tamil Nadu, it has passed many bills, nearly 10 bills were passed by State Assembly, and hence after getting passed they were referred to Governor of the state. Governor is R.N. Ravi in Tamil Nadu. So what Governor had done is, Governor initially did not act on these bills, meaning Governor neither gave assent to the bill nor rejected the bill nor sent the bill back to Assembly for reconsideration. Neither Governor reserved these bills for President's assent for first. And hence what the government of Tamil Nadu did is, Tamil Nadu government approached to Supreme Court. In such a case, Governor then reserved these bills for consideration of President. Even now Governor did not give assent, but then he referred those bills or he reserved those bills for the consideration of President, right. In such a scenario, Supreme Court of India in last April gave a verdict that if a bill is passed by Assembly, then Governor has to take a call on that bill within 3 months, right. If Governor returns the bill back to Assembly for reconsideration and then Assembly again passes the bill in the same manner, then in the second chance Governor has only 1 month to give assent, right. And if Governor reserves the bill for the consideration of President, then President also has only 3 months to act, right. So these time limits were set or were prescribed by Supreme Court in its judgment or basically Supreme Court had taken away the pocket veto power of governors in India. Now because it was considered as a very major change, it was considered as that power of governors have been curbed by Supreme Court. Now President of India has asked 14 very serious constitutional questions to Supreme Court. Let's discuss or let's see all of them one by one. The first question which is asked by President is, what are the constitutional options before a governor when a bill is presented to him under Article 200 of Indian Constitution? So as we all know, under Article 200, what happens is, if a bill is passed by the assembly, it reaches to governor, and governor has three options under Article 200. First option is to give assent, second is to withhold the assent, and the third option is to reserve for consideration of president. Now, because time limit has been imposed or has been prescribed by Supreme Court in its judgment, this second option of withholding the assent or keeping the bill with himself, this option has been taken away by Supreme Court. Now, President is asking how you are interpreting Article 200. As per Supreme Court, doesn't governor has the right to withhold, right? So this is the first question President is asking to Supreme Court, whether governor has this right to withhold the bill or not, right? Does governor has only these two options, either to give assent or reserve the bill, right? Does governor does not have the option of withholding the bill, right? That is the first question. The second question which is asked by the President is the governor bound by the aid and advice tendered by the Council of Ministers while exercising all the options available to him under Article 200. So let's say again a bill is passed by the assembly, reaches to governor. In such a case, whether it is mandatory for governor to take the advice of Council of Ministers and act accordingly. Doesn't governor has discretionary power here, right? So Supreme Court in its verdict had said that governor is not there to make law. Law making comes under the domain of legislature. In the case of state, it is state legislative assembly, right? Even if governor has some kind of reservation, what governor should do as per Supreme Court, governor should take advice of Council of Ministers, and if Council of Ministers suggests governor or advises governor to give assent, governor should give assent. If Council of Ministers advice to governor that governor should not give assent, then only governor should reserve the bill or withhold the assent. So here President is asking, is what are the options governor has, or is governor bound by the advice given by Council of Ministers? Doesn't governor has discretionary power? So does governor has discretionary power or not? That is what President is asking in question number 2. The third question which President is asking is the exercise of constitutional discretion by governor under Article 200 is justiciable or not? Meaning whether you can question in court the decision taken by governor under Article 200, which is a discretionary, power which governor has. So whether if it is a discretionary power, how can you question this judgment, or how can you question this decision of the governor in court? So that is what the question number 3 is. Then the next question which President has posed to Supreme Court is Article 361 of the Constitution an absolute bar to the judicial review in relation to actions of governor under Article 200 of Indian Constitution. For this, we should first be knowing what is Article 361. Article 361 basically gives impunity, legal impunity to both President and governor for their action taken, for their official actions taken, right? So whatever actions they take under official capacity, those actions they have legal impunity, meaning no case can be filed against either President or governors. So that is what President is asking now. If let's say governor under Article 200 does not follow the direction given by Supreme Court in the last judgment, does governor has impunity under Article 361 or not? If let's say governor does not give assent within 3 months, right, or the governor neither give assent nor withholds a bill or keeps a bill with himself, in such a case whether governor enjoys impunity or not under Article 361. Then the next question asked by President is, in the absence of constitutionally prescribed time limit and the manner of exercise of power by governor, can timelines be imposed and the manner of exercise be prescribed through judicial orders for the exercise of power under Article 200. So, the President is saying when in the Constitution under article there is no timeline mentioned, when in the Article 200 there is no manner of exercise of this power by the governor is mentioned, can Supreme Court through its judgment add timeline to Article 200? It is basically like Supreme Court is amending the Constitution. Supreme Court is amending Article 200, which is the sole power of Parliament. So, President is asking, if time limit is not mentioned in the Constitution under Article 200, can Supreme Court through a judicial order do it? Right? That is what the next question of President is. Question number 6, which is asked by the President to Supreme Court is the exercise of constitutional discretion by President under Article 201 of the Constitution is justiciable or not? So, under Article 201 means when governor reserves a bill for consideration of President, under Article 201 it reaches to President of India. So, whatever action President of India takes or the time limit of 3 months, if President acts or does not act within 3 months, are these actions justiciable? Can Supreme Court or can any court take up such matters, or can these decisions of President or governor or under Article 201 President, can these decisions of the President be questioned in any court? That is what President is asking. The next question is, in the absence of constitutionally prescribed timeline and manner of exercise of power of President, same thing like in 200 Article 200, when there is no time limit mentioned, when there is no manner of taking these decision is mentioned, can Supreme Court prescribe a time limit? Similarly, under Article 201 also there is no time limit or timeline given to President to take a call or to take a decision. Can Supreme Court through a judgment keep a timeline? That is what President is asking. The next question which President is asking is, in light of constitutional scheme governing the powers of President, is the President required to seek advice of Supreme Court by way of reference under Article 143 of Indian Constitution to take the opinion of Supreme Court when governors reserve a bill for the President's assent, right? So, let us say in case of governor, when a bill reaches to governor passed by assembly, in case of governor, Supreme Court had said governor should take advice of Council of Minister. But because the bill belongs to a state, when the same bill is reserved by the governor for President, President should not take advice of Council of Minister headed by Prime Minister in center, right? Because the bill belongs to a state, not to center. In such a case, President is asking, it is compulsory for President to take the advice of Supreme Court in such cases under Article 143, right? Can governor act, can President of India act on her own, or President will have to abide the advice given by Supreme Court under Article 143 and accordingly either giving assent to the bill or withhold the bill? That is what the next question of President is. Ninth question which President is asking to governor is, are the decisions of the governor and President under Article 200 and 201 respectively justiciable at a stage anterior into the law coming into force? So, President is asking is that before assent is given to a bill does not become a law. Under Article 13 of the Constitution, Supreme Court has the power of judicial review, that once a law comes into force, if a law is violative of any provision of Part 3 of the Constitution, such a law has to be declared as unconstitutional by the Supreme Court. But here the assent has not been given by the either President or governor. In such a case, the bill remains the bill only, not the law. President is asking, till the time a bill has not become a law, can Supreme Court or High Courts in India, can judiciary make or use the power of judicial review, right? So, because the bill has not even become law, because the assent has not been given either by governor or President, how can judiciary review such kind of bills? Then the next question which is asked by President to Supreme Court is, can the exercise of constitutional powers and the orders by the President or Governor be substituted in any manner under Article 142 of Indian Constitution? So, if you remember the Tamil Nadu case, the Governor did not give assent to 10 such bills, right? They were lying on the table of Governor, and later on Governor reserved those bills for consideration of President. What Supreme Court did was, Supreme Court, using its power under Article 142 of doing complete justice, Supreme Court said, because these bills are lying in front of Governor for very long time and Governor has not acted in order to do complete justice, these 10 bills will become act even without Governor giving assent to those bills, right? Now, President is asking, are the orders or the constitutional powers or orders of the President Governor, right, the power of giving assent, can they be substituted by the manner under Article 142 of Indian Constitution? Can Supreme Court give assent on behalf of Governor using its power under Article 142? That is what President is asking to Supreme Court. The next question posed by President to Supreme Court is a law made by state legislature a law in force without assent of the Governor granted under Article 200 of Indian Constitution? So, Supreme Court, for example, just now we have discussed, Supreme Court has declared in its order, because Governor has taken a lot of time and has not given assent, those laws will become act, those bills will become act. Now, President is asking, can a bill become act without Governor giving assent under Article 200, right? Then the next question is, in view of proviso of Article 145 subclause 3 of the Indian Constitution of India, or in Indian Constitution, is it not mandatory for any bench of this honorable court to first decide as to whether the question involves proceedings before it of such a nature which involves substantial question of law and as to interpretation of Constitution, and refer it to a bench of minimum 5 judges. So, what happens is, Article 145 subclause 3 very clearly says, if there is a question of, or if there is a very substantial question of law, or if such a case has come to court where they need to interpret the Constitution, in such a case Supreme Court need to create at least a 5-judge bench. A 5-judge bench. So, a constitutional bench of Supreme Court will at least be consisting of 5 judges. It can consist of more than 5 as well, but at least there should be 5 judges. So, President is asking, when this case of Tamil Nadu, where the power of Governor was challenged, right, or where Supreme Court has passed such a major judgment curbing the power of Governor, which involved a substantial question of law or which involved interpretation of Constitution, shall there be time limit prescribed to Governor or not? In that order, if you all know, that order was passed by a 2-judge bench of the Supreme Court, not a 5-judge bench. President is asking, shouldn't that case be first referred to a larger bench, a bench of at least 5 judges? Can a 2-judge bench deal with such a substantial question of law where interpretation of Constitution has to be done? That is what the 12th question posed by President. The next question which is posed by President to the Supreme Court is that, do the powers of Supreme Court under Article 142, so under Article 142, using this power, what Supreme Court has done in case of Tamil Nadu is, in the case of the Tamil Nadu Assembly versus Governor, is that Supreme Court had said, because Governor has not given assent for very long time, we are considering those bills to be passed. They are deemed to be passed because Governor did not act, and hence those bills have become act even without getting assent from Governor. Now, President is asking that power under Article 142 of Indian Constitution, does it only limited to matters of procedural law? That if Governor has violated any procedure, any law, if Governor has violated, right, then only Supreme Court should have used this power, or Supreme Court can use this power which is violative of the existing substantive or procedural provisions of the Constitution. So there are provisions or there are procedures under the Constitution which is established also. For example, it is established procedure that a bill after getting passed by the assembly will have to be given assent by governor, then only it will become. President is asking, can Supreme Court under Article 142 violate such kind of established procedure of law, right? That is what question number 13 is. And the last question which is asked by President to the Supreme Court is, does the Constitution bar any other jurisdiction of Supreme Court to resolve dispute between union government and the state governments except by the way of a suit under Article 131 of Indian Constitution? So try to understand here this case of Tamil Nadu, right? It was a case between governor and the government, state government of Tamil Nadu. It was because governor is appointed by center, it was considered as center state dispute, right? Now it is a very clear position or established policy or position that center state disputes can only be resolved by firstly Supreme Court, because it comes under Article 131 of original jurisdiction of Supreme Court, that if a dispute is there between center or state, or between two or more states, or between center and state on one side or one or more states on other side, such disputes can only be resolved by Supreme Court and not by anybody else, because it is original jurisdiction of Supreme Court. It is again, Supreme Court has said this in many cases, that such disputes we can resolve only under Article 131 and not under any other article. But many experts, they say that the dispute between governor and state assembly in case of Tamil Nadu, Supreme Court has used its power under Article 32. 32 is writ power, where Supreme Court has issued a writ of mandamus. Mandamus literally means do your duty, right? So Supreme Court has used this power of mandamus, issuing writ mandamus, to ask governor to do his or her duty, because governor is not giving assent, governor is not acting on the bill. President is asking, in case of center state dispute, can you give judgment under any other article than Article 131, right? So these are the 14 questions related to interpretation of the Constitution, related to interpretation of various laws, which have been asked by President to Supreme Court. Now it is up to Supreme Court whether advise to the President or not. So now the last part of this video is the decision of the President to ask these many questions to the Supreme Court. It is not just related to that particular case, it is part of that bigger debate. Firstly, by this judgment, what Supreme Court has done is, Supreme Court, by prescribing time limit, many legal experts are saying is, Supreme Court has kind of amended the Constitution, which is not the power of Supreme Court. So Supreme Court has done overreach, judicial overreach. So this is part of a bigger debate of judicial overreach, where Supreme Court start acting in the field of legislature or executive. Secondly, we need to maintain a fine balance or balance of power between three organs of the state, that is legislature, executive and judiciary. So separation of power, right, that many legal experts are saying this delicate balance is getting imbalanced because of this verdict of Supreme Court. So the reason for President to ask these many questions to Supreme Court is not just about one particular case, but about a bigger debate of separation of power and judicial overreach. And if you know, Vice President has many a time said that Supreme Court, them giving direction to President of India, Supreme Court judges which are not at all accountable, right? So judicial accountability is also one bigger issue which will be getting addressed from these questions. So I hope you have understood the legal aspect of these 14 questions, why these 14 questions were posed, what is the meaning of these 14 questions. If you have liked this video, please do share our channel. Thank you.